as I've said, the government did cooperate. But more importantly, to say that the government ought to have instigated the process of evidence collection, while we know that the investigators who are ICC investigators is being preposterous.
On the Deputy President?
On the Deputy President?
They have ruled that that recanted evidence will now be used in essence. So witnesses that then came out to say, had said one thing initially, then now are saying no, because the judges have found there was evidence of interference, that there were people who were sent out to meet these witnesses, or they gave them money or some form of interference. That, yeah.
I think in the entire scope of criminal jurisprudence, that thing is simply out of the box. I just don't understand how that judgment was arrived at. First and foremost, there were undertakings, albeit they were not committed in writing, that these laws of Rule 68, as it is popularly known, was not going to apply retroactively, so that it was not going to apply to the case of the President and the case of the Deputy President during the time that the state parties were negotiating them. That was very clear. Secondly, as to whether there was evidence of interference or not, I think that should not have been ground enough to allow recorded evidence to be used which cannot be subjected to cross-examination. When you have a man or a woman stand in the dock and you are able to ask him questions, not only are the answers gleaned out of what he's saying, but you are also able to study the demeanor of that person there. You are able to say he's lying, he's not lying, he's saying half-truth or non-truth. So I think this is just a bad precedent.
But can you not bring evidence to the contrary?
Evidence to the contrary to what extent?
When then there's evidence that was written, yes, by these witnesses that have recanted, then you come and show, in fact, they said this and this meeting happened. No, this is what was happening at this particular time.
Then what we are simply saying is, yes, the defense will be allowed to bring evidence to the contrary, because they have no otherwise. That is the only way they'll get out of it. But what we are saying is that was a bad judgment. In a sense, what they are saying, or the precedent they are setting, is that people will go and record statements and incriminate you even illegally, and then disappear. They don't have even the obligation to turn up in the court to be cross-examined, to be subjected to the rigors that come with answering questions when you're faced with with people from the other side. So I think it is simply something out of place. When you look at the Vienna Convention of 1949, you look at the Rome Statute and all international treaties, you cannot actually bind a man by a treaty that was not operational at that time. So you cannot apply that law retroactively.